Hello and welcome to another view from Mayor Brown. This sits alongside our regular podcast and is an occasional series of interviews with those involved in the changes going on in employment law. The podcast is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 88. We like to think of ourselves as the podcast series that is equivalent to the Daniel Barnett Masterclass, but without Daniel Barnett, or the dry ice, or the spaceship descending from the ceiling. Well, in this podcast we're going to be looking at three cases. The first considers an interim injunction application requiring the defendants to allow an independent expert access to their computer systems to undertake a search for the claimant's confidential information, which, the claimant argued, was being misused. Then, secondly, we have an EAT case dealing with a service provision change in a case where there was a temporary cessation of work prior to the change of service provider. Key question was whether employees who were not reporting for work at the time of the alleged transfer could still transfer under TUPE in spite of that temporary cessation of work. And thirdly, we've got an employment tribunal case which considers whether an employee was fairly dismissed for disclosing confidential information via Bloomberg messages. Well, first case then, Arthur J. Gallagher Services UK Limited and others against Skripchenkov. My apologies to Mr. Skripchenkov if that's not the right way of pronouncing his name, and others. This is a High Court decision in which the claimants, members of the A.J. Gallagher Group, applied for an interim injunction against the defendants, former A.J. Gallagher employees, and their employer, their new employer, a rival company called Portsoken Limited. The injunctive relief being sought by A.J. Gallagher related to confidential information contained in documents that A.J. Gallagher alleged Portsoken staff had retained following their termination of employment at Gallagher's. In this case, specifically, Gallagher's was applying for a court order that Portsoken's computers, work computers, be searched in advance of the main trial, and if any confidential information belonging to Gallagher's was found, for this to be deleted from their systems permanently, with only a copy retained as evidence for the trial. To give you the background to the case, I can't say the facts because this has not yet gone through full trial. Gallagher's claimed that Skripchenkov had taken confidential information on leaving Gallagher's and that this confidential information belonged to Gallagher's, and it was alleged that he was using this information after termination of his employment to approach Gallagher's clients around the dates of their policy renewals on behalf of the new employer. The confidential information supposedly included details, names of clients, renewal dates, information about current rates and premiums. Well, Gallagher applied for an injunction, and it was said that Portsoken Limited had admitted to having this information and loading it onto their own digital platform. This was despite having provided undertakings to Gallagher's that it would not use the confidential information to deal with restricted clients. Well, Gallagher's alleged that the disclosure produced in this case clearly demonstrated Portsoken Limited's misuse of information, and the disclosure consequently resulted in additional claimants and defendants being added to the proceedings. Following disclosure, Gallagher's also applied for more extensive relief, requiring the defendants to provide access to an independent expert to search their computer systems, and the searches of their systems requested by Gallagher's were in respect of any confidential information belonging to Gallagher or documents derived from this information. Gallagher requested in its application to court that should any such information be discovered by the independent expert, that it was going to be deleted, with copies only being retained for the purpose of the injunction hearing itself. And the court decided it did have the power to make such an order to permit the independent expert to undertake this search and to delete exercise. However, it concluded such an order would only be appropriate where it was necessary to prevent the defendants from having access to Gallagher's confidential information. In this instance, the court decided on the facts it was appropriate to make an order for the defendants' computers to be searched, and for a mandatory injunction to be granted requiring the defendants to stop using any confidential information located on their computer system, and for such information to subsequently be destroyed. However, the court determined that in order for this interim relief to be granted, certain safeguards had to be in place, namely a process allowing the return of deleted material to the defendants as necessary. In coming to its decision in this case, the court applied the American Cyanamid principles, meaning that a certain degree of assurance was required that the claimant would obtain injunctive relief at the main trial in the form sought at the interim stage, in order for the court to provide the interim relief. Court held that this assurance, this test, had been met here, concluding that it was likely the court would conclude in the main trial that the defendants had taken confidential information and had used it for their own business purpose. The court in this case concluded, on an interim basis if you like, that a destruction order was likely to be made against the defendants at the main trial. Further, the court held that although the defendants had complied with the previous interim order, Gallagher's was entitled to this additional protection on the basis that the defendants are not entitled to have or to use confidential information belonging to Gallagher's and, in the view of the court, could not be trusted to police themselves in the search for and destruction of such information. Well, I think the decision is a really interesting one, and I mean it because it deals with a common issue that faces clients and those trying to enforce injunctions generally, concerns over confidential information, if they believe former employees are acting in breach of restrictive covenants and or have taken confidential information. And the case is a helpful one for employers who are seeking to protect that confidential information. If they believe it's being misused and it's being held electronically and it's being used against them, and this case demonstrates how in coming to a decision to award mandatory injunction, the court may look at the balance between the risk of misuse by the defendants and the scope and effect of any order granted by the court. In this case, the court clearly felt that the interim relief granted involved the least risk of injustice to either party, and that damages would not be an adequate remedy in this instance for Gallagher's if it turned out that confidential information was being used against it. Also, what's interesting is that the parties here were ordered to agree the appropriate search terms for the independent expert search of the defendant's electronic database, and failing agreement, the court would set the search terms. Equally, the court recommended a dispute resolution procedure to decide whether material found as a result of the search contained confidential information belonging to Gallagher, if this couldn't be mutually agreed by the parties. To this end, the case clearly shows the court's attitude towards both the defendant carrying out the searches unilaterally on its own behalf, as well as their view on the search terms themselves, with the court here ordering the searches to be carried out by the independent expert. This followed Gallagher's argument that it would be unacceptable for the defendants themselves to carry out the search process and police it fairly. All in all, I think it's a really important case and a helpful one for employers. I'm absolutely sure we're going to see this case deployed in contested departure cases on an increasingly regular basis. It is a High Court decision, that's the level, but it clearly points the way to a very powerful remedy. Defendants are going to hate the idea of an independent expert coming in and searching their databases. Equally, it's quite easy to see such search might turn up other material in the defendant's systems, which either the defendants say has been obtained legitimately relating to, for example, common clients, or it's going to turn up material which the claimants had no idea about, but is found that the defendant has obtained it inappropriately from unknown sources. All in all, I can see battles about the search terms for which things get searched for, what period the search relates to, etc., etc. Additionally, if you're a defendant, you might worry that there's been deletion of offending material from the database systems of the new employer before the search is undertaken. And if that happens, of course, then there'll be potentially devastating consequences for the new employer if one or more of its employees are found to have deleted material inappropriately. So, that's the case of Arthur J. Gallagher Services UK Limited and others, and Skripchenkov. So, the next case, Mustafa and another, and Trek Highways Services Limited and others. Well, this recent EAT case considered the application of TUPE in a rather complex and, to be honest, quite a fact-specific situation, where the employees who were allegedly transferring under the regulations had ceased working several weeks prior to the transfer date on the activities in question. However, the EAT, in looking at this, made a number of really quite helpful pronouncements about the way TUPE, and in particular the service provision change rules, apply. And it's these pronouncements, rather than the underlying particular fact pattern, that are helpful. Let's bit of background. A relevant business transfer is applicable in situations where the economic entity keeps its identity following the transfer, and that's the old Speicher's multifactorial test. However, TUPE can also apply in the event of a service provision change, an SPC. And an SPC can be implemented in three circumstances, including the client assigning their work to a contractor handing that work back to a new contractor, or the services being brought back in-house. In order for there to be a service provision change, the court would need to accept that the services are not simply going to be provided after the transfer for a short-term duration. This is the so-called short-term duration defence. Both the organised grouping point and the short-term duration point are relevant in this case. Where TUPE applies, the transfer operates obviously to transfer the contract's employment over, and as is also well known, service provision changes, the rules were brought in to ensure that in cases where it was unclear whether or not TUPE applied, TUPE would be found to apply more easily. It tilted the balance, if you like. Well, in this case, Mr. Mustafa, the claimant, worked for Amey, and they'd been awarded a highway maintenance contract in London. Amey subcontracted its traffic management work, which Mr. Mustafa worked on, to Trek. Consequently, Mr. Mustafa TUPE transferred from Amey to Trek and continued to work in traffic management for the ultimate customer, TfL. Amey's highway maintenance contract was subsequently put out for tender by TfL and won by Ringway. As a result, 2 weeks before the anticipated transfer date, Trek stopped providing the relevant services to Amey. Ringway then started providing services under the contract 2 weeks later. They did not bring forward officially the transfer date. But 2 weeks prior to the transfer date, a legal dispute had arisen between Amey and Trek, and that resulted in Trek refusing to undertake any of the services and telling its staff, including Mr. Mustafa, that they were transferring back to Amey. Trek employees were told there had not been a TUPE transfer to Amey or Ringway. Trek goes into liquidation, and Mr. Mustafa then, of course, claims against the solvent targets, i.e. Ringway and Amey, that his employment had transferred under TUPE. The question, and it loomed large in this case, was to what extent was it relevant, amongst other things, that Trek had voluntarily stopped providing the services 2 weeks before Ringway took over providing services, and I'll come back to which services in a second. Mr. Mustafa claimed, in fact, there had been 2 potential TUPE transfers, and the first was a transfer from Trek to Amey for the balance of the period when Trek were not providing the services, and then on the anticipated start date for Ringway, he said there was a transfer from Amey to Ringway. The Employment Tribunal decided there had not been a business transfer under the ordinary provisions from Trek to Amey, ordinary TUPE provisions, I should say, from Trek to Amey, nor had there been a service provision change. Now, there were a number of reasons for this, but key for our purposes was that they found that for service provision change purposes, which was always going to be easier for Mr. Mustafa to meet that particular test, there was no organised grouping of employees prior to the transfer because 2 weeks earlier Trek had stopped providing the services. Secondly, the tribunal accepted that at the point at which they'd stopped doing the services and Amey took over providing the services, it was only for the very short period before Ringway took over providing the services on a permanent basis. Therefore, it was claimed by Amey that the contract was of a short-term duration, and the tribunal accepted that. Well, Mr. Mustafa appealed, and the EAT allowed the appeal. And there are 2 key points which I wish to focus on. First, the fact that Trek stopped providing the relevant traffic management service ahead of the stopgap arrangements that were put in place by Amey to cover the short period before Ringway were able to take over, did not prevent there being a transfer from Trek to either Ringway or Amey. As a matter of statutory construction, there is nothing in the service provision change rules that require the organised grouping of employees. One of the things that is required, remember, it's not required that that organised grouping is carrying out the activities at the point of transfer. Secondly, under the ARD provisions, there's plenty of authority that says that merely because a business is closed temporarily, e.g. it's a seasonal business, does not prevent there being a transfer under the directive and therefore under the TUPE regulations. Thirdly, the AT said that this inactivity was merely a factor to be taken into account. Here, the employees had not been dismissed. Trek had simply suspended its services and could have resurrected them at a moment's notice if there had been a resolution between their dispute between Trek and Amey. The argument that the tribunal judge accepted on the short-term duration point was also rejected by the EAT. The EAT pointed out the activity was formulated to be the traffic management system. That activity was going to continue while Amey did it, and then when Ringway did it. The fact that Amey was only going to do for a short while, pending handing it over Ringway, did not make the activity, as opposed to the stopgap arrangements, it did not make the activity temporary or of short-term duration. I think that's quite a helpful clarification and entirely logical. Finally, we would have to give a shout-out to the case of ADI and Willow, which gets a name check here. because the EAT in this case accepted that where employees were not taken on by the alleged transferee, it was necessary to look at whether the transferee was evidencing an intention to avoid taking them, because it would have meant there was a transfer. Since we did the case of ADI and Willer all those years ago, and we won on this very point in the Court of Appeal, it's nice to see that that authority is still alive and kicking. So, the ATE case is authority for the fact that both with service provision changes and ordinary TUPE transfers, the fact that business activities are suspended in the allegedly transferring business does not prevent there being a TUPE transfer. Similarly, short-term duration contract does not mean that the activities are of short-term duration. It's the activities that need to be of short-term duration, not the contract. And these are practical points which transferees in particular would do well to bear in mind. So that's the case of Mustafa and another, and Trek Highways Services Limited and others. Final case is Stimpson and Citibank, and this is an employment tribunal case which looks at whether an employee who was dismissed for sharing confidential information via Bloomberg Messages was unfairly and wrongfully dismissed. I wanted to put the case in the podcast not so much for this specific case itself, because it illustrates a possible point in disciplinary cases. I think many employers hearing about the case, especially if they're not familiar with the vagaries of the English employment tribunal system, might be slightly surprised at the outcome. Also, as I've said before on this podcast, how a case looked at the end of a hearing can be very different from how it rightly and understandably looked to the parties at the start of the hearing. Who knows, this may be one such case. By way of a quick legal background, in order for the employer to be able to dismiss an employee fairly, the employer must show that there was a potentially fair reason for the dismissal, and misconduct is a potentially fair reason, of course. But if it's misconduct, then there's a need to genuinely believe that the employee is guilty of misconduct and that they had reasonable grounds, and it's necessary for the employer to show that they had carried out as much investigation as was reasonable in the circumstances, and if you're going to dismiss someone, of course, then that dismissal needs to be within the range of reasonable responses. So that's the test in connection with unfair dismissal. In relation to the test for wrongful dismissal, breach of contract, of course, an employer must show the employee has committed a repudiatory breach of his or her employment contract in order to be able to dismiss the employee without notice. It's not a case of the employer believing something to be the case. It actually needs to be the case. The facts of this case are pretty complicated and span quite a long period of time. So I'm going to provide just a brief summary. And as I say, I'm really looking at this case because it's a jumping off point for a wider issue. The case involved an employee who was employed by the bank as a trader on a foreign exchange desk. In 2009 and 10, he was encouraged by his manager to join Bloomberg Online Chat to get better market information. It was common in the industry for banks to have access to Bloomberg Messages and for traders to message each other on chat rooms. Mr. Stimpson was not given any specific guidance about what information should or should not be shared on the chat room, and as you would expect, the bank had the usual codes of conduct in place, which included strict rules in relation to the sharing of confidential information. Employees were also provided with a handbook, which also set out rules about the non-disclosure of confidential information. Under the bank's disciplinary policy, an unauthorised disclosure of confidential information was set out as a specific example of gross misconduct, which could lead to immediate dismissal. OK, fast forward 3 years, 2013-2014, the bank issues a specific instruction to foreign exchange traders telling them to stop using the chat rooms to share information with other traders. At a similar time, an independent regulatory investigation was commenced by the FCA into the foreign exchange business, and the employee was invited by the bank to attend those interviews. A few months later, he was suspended and then invited to attend a formal hearing to address allegations that he had, on 12 occasions in 2010 and 2011, inappropriately shared client confidential information on Bloomberg chat rooms. The bank alleged that this conduct amounted to a breach of the implied duty of fidelity, and also that he breached the specific policies in the employee handbook and the codes of conduct. A global business head was appointed to chair the disciplinary process, and he limited his review to the 12 incidents and the bank's policies. The employee's main defence was that his actions were in line with the normal culture of information sharing at the bank, and moreover, that such culture had been encouraged by senior managers. He also argued that he did not consider himself to be bound by confidentiality rules in respect of certain clients whose activity was in the public domain. As a result of the disciplinary hearing, he was summarily dismissed. At the same time, the FCA concluded its investigations into the foreign exchange desk and imposed a fine, somewhere over £200 million worth, for various offences including the bank's failure to control the inappropriate sharing of information with traders at other firms. It appears that this was not taken into account for the purposes of Mr. Stimpson's disciplinary investigation. Mr. Stimpson appealed against his sanction, but his appeal was dismissed, and subsequently he brought claims for unfair dismissal and wrongful dismissal at the tribunal, and these were upheld. The tribunal agreed with Mr. Stimpson that his dismissal was both unfair and wrongful. In relation to the unfair dismissal claim, the tribunal found that the bank had not dug deep enough, didn't really consider his defence that the culture of the bank was such that he honestly believed he was not committing an act of misconduct. Nor, they found, was any real weight given to his suggestion that senior management had encouraged a flexible approach in relation to confidentiality. It would not have been enough for the employer to look at the policies without giving consideration to the extent to which the policies were known and applied in practice, according to the tribunal. The FCA notice clearly stated the culture of the bank was such that there was no strict adherence to the policies in relation to confidential information, and there was a culture of inappropriately sharing confidential information. Mr. Stimpson had a clean employment record of 25 years, and he had stopped using the chat rooms in 2013 once specific management instructions were given. As such, the bank was found to have failed to conduct a reasonable investigation, and dismissal was not within the range of reasonable responses. In relation to the wrongful dismissal claim, the tribunal found that the individual's conduct did not damage the relationship of trust and confidence to such an extent that the bank would be entitled to dismiss it without notice. In reaching this decision, the tribunal followed previous case law and found that although Mr. Stimpson's disclosure of confidential information was not inadvertent, because he did deliberately disclose it, this did not mean that it was a deliberate breach of his duties, as he reasonably believed that such conduct was permitted and, in fact, encouraged. Well, as I say, I wanted to mention this case, not so much because of the facts of the case, and I'm sure there are other cases, and there may well be different outcomes in other cases, but rather it's a common problem which we have seen in other cases. The employer feels that something has gone badly wrong. It identifies the people who have perpetrated the mistake and then proceeds to punish them. I have no way of knowing whether this is what happened in this case, but you could understand that an employer in this sort of situation saying to himself that it could not be unfair to dismiss the people that had done some things that led to payment of a £200 million plus fine. So I think the real issue in this sort of case is the process that's adopted by the employer. To that extent, it's essential to bear in mind that employees' defences must be considered and must be seen to be considered and responded to at the level of the disciplinary hearing, and certainly before dismissal. Indeed, one of the things that we sometimes do is to advise clients to prepare a draft of the disciplinary outcome letter and share that draft with the employee. This way, the employee gets an additional opportunity to comment on the reasoning and presumably if any points are not being addressed sufficiently. To use the analogy in this case, if the employer is convinced that the employee has done the act that caused the harm, this does not mean that the employee should be dismissed. That particular shortcut leads to tears. So that's the case of Stimpson and Citibank. I think it only remains for me to say that thank you very much for listening. Assuming between now and podcast 89 we don't line up a podcast masterclass tour taking in England's premier tribunal beauty spots, stay safe until podcast 89 and keep your ears peeled. We're going to do an announcement shortly about a podcast on equal pay, and in particular the equal pay audit provisions, which I think are of quite some significance for employers and need to be thought about now rather than putting off the evil moment to when you actually have to go live with your reporting and stats. As ever, of course, please remember we post out on Twitter, the case links, etc. are on Twitter, Nicholas Robertson at Nicholas ROBER11. We are on YouTube and the Mayor Brown intranet, as well as iTunes. Do please subscribe, of course, because that way podcasts come to you automatically rather than you having to remember to download them. But I'm conscious that some people prefer to look at us on YouTube or indeed the Mayor Brown intranet. So, thank you very much indeed for listening, and stay safe.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.